if we could take our seats, please. We're going to resume right now, if we could, and try and stay on time so that we can finish on time and then proceed to the reception. There are two slight changes in the program that I want to make you aware of. Perhaps most importantly, the reception after this final panel is going to be in the East Room, right next door, so don't go to the Chinese room. But I guess truly more importantly, our moderator for this panel is now, I guess, a new father by now. We heard yesterday that his wife had gone into labor, so he wouldn't be able to join us for the panel. But David Rivkin has graciously agreed to fill in as our moderator. David is a partner at Baker & Hostetler. He has rich government service, serving both in the Reagan and Bush 41 administrations, in the White House counsel's office, and in the Department of Justice. Some of you undoubtedly have heard of him. His columns appear regularly in the Wall Street Journal, the Washington Post, the Washington Times, and elsewhere, where he writes on international law issues, and particularly laws of war and executive power. And from my perspective, even more importantly, he's a great friend of the Federalist Society. So, David.
Thank you. Let me briefly introduce the two panelists, not that they need any introduction, and then I will make a few remarks, and we can turn to what we all came here for, which is to listen to excellent presentations. The three gentlemen who will speak shortly are in the order in which they appear. Professor Jeremy Rapkin, who is a professor now at George Mason and the author of many books on international law, including most recently Law About Nations, Why Constitutional Government Requires Sovereign States. He was previously a professor of government at Cornell. Next, we're going to hear from Professor Meggs from GW University, who previously taught at the University of Texas, done a great deal of writing in the area of constitutional contract and counterterrorism law, clerk for some of the better justices in the Supreme Court, and has many other accomplishments. And the last speaker would be John Yoo, who is now at Bolt. Well, as most of you know, had a very distinguished tenure at OLC for a number of years early in this administration's term. Well, let me briefly say a couple of things. It's my pleasure to moderate this very distinguished panel for a couple of reasons. I'm good friends with most of the panelists, but I'm also a great fan of Judge Bork and his work. In fact, his was an early and prescient voice about the deleterious impact of what passes for international law these days. He certainly saw the problems that this has posed for our particular body polity long before the magnitude of the problem became apparent. In sort of setting the stage for the discussion to follow, let me just say a few things. In my view, at least, the problems we've encountered with the misuse of international law by U.S. courts, most prominently, but also, frankly, in the broader political discourse and punditry, are not necessarily endemic, and they don't stem from the nature of international law. Indeed, international law properly conceived, what I would call traditional public international law, the laws of war being its major component, really did not pose and shouldn't have posed much of a problem for law-abiding states. It featured a modest set of broad rules rather than a regulatory straitjacket. Those rules are perfectly compatible with the imperatives of sound statecraft. Even within the universe of these rules, states could certainly derogate from the established norms, ability to derogate, of course, being a key attribute of sovereignty. And customary international law evolved gradually in response to specific problems that were facing the international community and were based solely and exclusively on state consent. In fact, even state practice was not sufficient automatically to give rise to binding norms. They were driven by considerations of diplomatic politesse or other policy factors. Rather, it was opinio juris, a perceived sense of legal obligation that was an indispensable indicia or requirement for a norm of customary international law to arise. It was also clearly understood that customary international law was not uniform, was, I would call, granular, which is to say different set of rules applied to different set of states, because one set of states subscribed to particular customary norms and others did not, functioning in effect as persistent objectors. It certainly wouldn't have occurred to the former to claim that the latter was somehow bound, but them being aware of it. Then it came to treaties. It was the prerogative of sovereign states to interpret the meaning of obligations they have endorsed. To the extent the treaty parties differed, and that happened quite a bit, the disputes were resolved either through diplomatic dialogue or perhaps for use of force. They certainly were not usually litigated in international courts. Needless to say, the so-called universal jurisdiction did not exist, and the notion the courts of one sovereign would sit in judgment on actions done by agents or officials of another sovereign would have been viewed as preposterous. This is what I call the good old days. I guess what I'm trying to say is that before international law began to function as a tool in an effort to distort our policy and legal discourse, it had to become warped itself, abandoning all the substantive and procedural restraints that I've just mentioned. I think we should all recognize that the misuse of this newly warped international law is a particular problem for the United States. This is a case for a couple of reasons. The most obvious one is that both our enemies and allies use the language of international law for a range of purposes, but primarily to discipline and constrain American power, operating both domestically and the world stage, a phenomenon broadly called lawfare. The less obvious reason, but reasonably obvious reason, why claims phrased in the parlance of international law have become a core part of various debates in this country. Again, not just about international issues, but domestic issues as well. It has to do with who we are, sort of what is unique about our body politic. I'm sure I'm not telling you anything new if I mention that most of our debates tend to be framed in legal and constitutional terms. I'm not going to quote de Tocqueville to you, but you all know what he said. And he was clearly right both about the time he wrote, but even now, even the Constitution's framers began to spar over the meaning of a document they adopted almost as soon as the ink was dry on this document. And in 1790s, for example, Hamilton and Madison clashed over the president's foreign policy prerogatives relative to those of Congress in the famous Habeas Pacificus debates. Although, frankly, at least in my view, the real issue was not the constitutional one, but a rather pragmatic question of whether the United States should support the French or the British in the French Revolutionary Wars. To be sure, this is not the tendency to deploy the language of law is not unique to the United States. Appeal to some form of higher law is common around the world, since if you can frame your preferred political outcomes as something that's allegedly legally required, it makes winning the debate that much easier. And international law, unfortunately, is tailor-made for these purposes. It's not made by the legislature. It's even more amorphous than legislature-made law. There are no reliable sources that you can cite, and pretty much you can cite sources on both sides of every proposition, and there is no institution that is authoritatively entrusted with the task of interpreting its requirements. So international law has become uniquely suited for use in policy arguments. And traditionally, of course, this is how states, who are, as I mentioned, in traditional public international law, the ultimate arbiters of its content and application, have liked it. I mean, claims, I don't want to say that claims, sort of policy-sounding claims about international law have not been made before, but they were made in a somewhat cynical way. They were made as a convenient adjuncts of state policy, and it is a rare government that would say about its own conduct that its actions violated international law. You frequently said you made this point about your adversaries. Well, what does it leave us with? I mean, can anybody really tell us what international law is? And to me, the answer to this question is don't pay much attention to what other countries say about what claims they made regarding the content of international law in general or the alleged illegality of American conduct, which is one of the most common claims these days. Concentrate on what states have actually done in actual practice. Now, that said, it certainly can be well questioned, and Judge Bork has posed this particular question: is international law at all? I think it's fair to say that it is not law in a traditional sense of a domestic legal code adopted by legislatures through an accountable and democratic process and enforceable for some judicial mechanism. But in some ways, it's probably, at least in my view, a bit more of a natural law from which it evolved. International law is best described and understood as a collection of behavioral norms, some arising from custom and some from express agreements, some more or less well established, some less established, that it is in the interest of states to honor most of the time. With respect to those norms that are well and truly established, states do usually comply, and they do so out of a sense of some obligation, but also believe it in the long run it inures to their benefit to do so. However, if the states choose not to comply, and I mentioned at the beginning that derogation is one of the attributes of sovereignty, then the question stops being purely a question of law. Unlike in a domestic setting, it becomes a question of policy and politics. Efforts to change this state of affairs, particularly through the creation of supranational institutions with alleged authority to declare what international law requires and then to enforce that view against states or individual citizens, is both misguided and illegitimate. They're misguided because they actually ignore how the world is organized, namely into sovereign and independent states. They're misguided because it is that very organization into separate and sovereign and equal sovereignties, but for all of its flaws, has helped promote the growth of liberty and free markets both in this country and overseas. Well, let me stop here and turn the conversation over to Professor Apton.
Can I go up there?
By all means.
Well, I think it's a tribute to Judge Bork that so many of you have stayed this long. I was asked to speak from 30,000 feet, which I'm actually feel sort of qualified to do because I just made a trip from overseas and was flying at 30,000 feet. Just got back yesterday, and I can report to you that from 30,000 feet in one of those big jets, if you sit in the middle and you fly at night, you don't see anything. So I was a little nervous that I would not have enough to say, and then I passed out. If I don't do anything else before I sit down, I will do a good deed, and I'll do something which is really worthwhile to your, what do they call it, continuing legal education. If I direct you to the article that Judge Bork published, which they've made copies of and are handing out there in the back, The Limits of International Law. It's quite a good article, but I particularly draw your attention to this on the last page. International law thus serves, both internationally and domestically, as a basis for a rhetoric of recrimination directed at the United States. Those who disapprove of a president's actions on the merits, but who fear they may prove popular, can transform the dispute from one about substance to one about legality. The president can be painted as a lawbreaker and perhaps drawn into a legalistic defense of his actions. The effect is to raise doubts and lower American morale. And what's really impressive about this is it was written in 1989. 1989 was it could have been said any time. No, this was good that he saw this almost 20 years ago. 1989, Francis Fukuyama was already working on the end of history. I mean, the arguments were over, we all agree, blah, 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 and therefore international law. I will say he even then had a good taste. I mean, he picked up who were masters of fatuity. I was particularly struck, he mentioned my former colleague at Cornell, Herbert Briggs. He was not exactly a colleague, he was already retired, but he'd published something in the 80s, an old man by then, condemning the attack on Grenada as being against international law. Liberation of Grenada, if you like. And I was struck by this. I had forgotten what he had said about Grenada. I don't know, it didn't impress me, but just shortly after that, he died, and they were cleaning out his office, and I went in to make condolences to his widow who was cleaning out the office, and one of the best things there was he had mementos from his trip to the signing of the Kellogg-Briand Pact to put an end to war in 1927. And what was particularly striking about it was he was on the same ship with the young Alger Hiss, joining him in that venture. Judge Bork just kind of sniffed who were the most pompous and fatuous and phony. One of the things he says there, I think the central point that he tries to make there is people are making very legalistic arguments about what is and isn't allowed under international law, removed from any context that ordinary citizens could make sense of. He says one of the costs of a very legalistic approach to international law is that you drain any moral or ethical content from it. I think that's a very powerful and true point, and something which, if you just look at the debates we're having in the world today about Guantanamo or coercive interrogation or was it right to have overthrown Saddam Hussein, we get very quickly into a kind of legalism which abstracts from what was this really about and what are other people doing and what would happen or might have happened if we didn't do it. I think it's notable that Judge Bork, in that book that I guess is given the title of our panel, Coercing Virtue, constantly complains about an approach to law which is not just legalistic but also unreal, and unreal even with regard to what is or isn't law. He saw already, it's whatever it is, 7 or 8 years ago, judges were starting to cite each other in a very cross-national boundaries, to mention international treaties without precisely saying, here's what it means and it's binding. He saw that transnationalism was related to a kind of flipness or a kind of sloppiness about what was real law and what was an ongoing discussion. I think he also showed a kind of seriousness about facts or reality from or with regard to things that could be displeasing. I give one example that I think is important. I think had something to do with the origin of that book. I remember his asking me, along with other people, about Canada, because I had somewhere mentioned something in print about the new Canadian Constitution allows the Parliament to override constitutional decisions of the Canadian Supreme Court. And he was very excited about that. He thought that was a great idea, to be able to override decisions of the National Supreme Court. And so I told him, well, I don't really know anything about this, but I've heard it doesn't work so well, and you should talk to this person and that person. And he pursued this, and he talked to some people, and one of the chapters in that book is the Canadian Supreme Court is running wild, and it hasn't been restrained at all by the Canadian Parliament, because although they have, in theory, this capacity to override, they never actually invoke it. They don't do it. And he's pretty clear about this. Public opinion was not indignant about the activism of the Canadian Supreme Court. It was not certainly indignant enough to encourage politicians to get in the middle. The realism that he had about that, I mean, what can you expect people to get indignant about? I think is related to a tone that comes through in the article that he published in 1989, which sounds also kind of hard-headed about what the world is like. And some people confuse this with what's called realism as a school of international relations, which is everything is about power, which I think is a real misunderstanding of what he has thought. But it's true that if you complain about coercing virtue, you're not expecting too much virtue. I mean, the title of the book already suggests there's something hopeless about coercing virtue. I do not think what he meant to defend in that book was cynicism or kind of brutal preoccupation with power relations, but the international counterpart of really powerful forces that we live with at home, starting with private property. People do care about holding on to their own. In 2000, he was already saying, look, judges are citing each other across boundaries. And I think that was not only prescient, because it hadn't happened very much in the United States, but it was also, I think, a good instinct about what people might be upset about. He already had the experience that a lot of arguments about original intent didn't have a lot of political traction. The country was not, that is the United States, was not any more worked up about whether Supreme Court decisions were or weren't rooted in the Constitution than people in Canada. But he had this good instinct that people would find it really offensive to have foreign authorities invoked to tell us what our Constitution meant. And as I say, I think that was prescient. I myself have been surprised at how much indignation there's been among congressmen who don't seem to be paying attention to much of anything. People who watched the confirmation hearings of Chief Justice Roberts, or Judge Roberts as he was at the time, and Judge Alito, the people asked them, what do you think about citing foreign precedents to interpret the United States Constitution? Senators who are not too interested in natural law, due process, history, they went right for that. Should our Constitution be what the French says it is, or what American taxpayers are paying for? I think that was a good instinct on Judge Bork's part, and I think it's a reason why we ought to be encouraged about the future. I want to say one other thing before I sit down. I didn't learn anything from being at 30,000 feet, but I did learn something when I was abroad. I was in Israel last week. One of the people I got to speak to was a graduate of the Yale Law School who was a student of Judge Bork's there a long time ago, who now writes for the Jerusalem Post and has written a lot of things attacking the Israeli Supreme Court, which is, Israel's a very exceptional country, and therefore it has the most exceptionally activist Supreme Court in the world. I think it's fair to say in the modern world. And this guy, Jonathan Rosenblum, I said, well, I'm going to have to say something about Judge Bork's work, and you were one of the people he interviewed when he wrote the chapter about the Israeli Supreme Court, and what about this? And he said, oh, the tide has really turned. When Judge Bork wrote that, he was one of the only people outside of Israel who was saying this, but now there's Judge Posner, and there's this person and that person. He's been collecting a file of people who have noticed in the outside world. And what's more to the point, now people in Israel are saying this, including the current prime minister. There is pushback. And what that tells you is there are some kind of natural responses which may be delayed, but will still come back. Cornell Physics Department has this really great poster, Gravity, not just a good idea, it's the law. And I would say Judge Bork's view of international law, or at least international morality, which is connected to his view of the importance of property and markets at home, is rooted in a kind of instinct that beneath the legalism there are real powerful forces which have a certain claim to be respected as law, and the need of nations to defend themselves is one of them. And to the extent that you talk about international law, you should be always mindful that at the end of the day, law has to make claims to citizens which they can find somewhat cogent, somewhat intelligible. And international law that's mere legalism is going to leave people behind, and eventually gravity will reassert itself. At least I'm somewhat hopeful of that, and I'm very grateful to Robert Bork for having engaged my interest in these things and alerted me to things years ahead of other people who didn't read his books, weren't on the alert for them. And in the end, I think people who say he was just a curmudgeon really miss how much he had this moral center of gravity of his own. Gravity, as they say, is a law. Thank you.
Next.
David, thank you very much for that kind introduction, and also thank you very much to the Federal Society for inviting me to speak here today. It's an honor and pleasure to be here this afternoon and to discuss Judge Bork's contributions to international law. In dividing up the responsibilities among the panelists, we agreed that while Jeremy would speak at 30,000 feet, I would have my feet on the ground and talk about Judge Bork's D.C. Circuit opinions. If my remarks today had a title, I think the title might be Judge Bork's Remarkable Adherence to Unremarkable Principles of International Law. I want to talk about 4 cases, Demjanjuk v. Mies, Persinger v. Islamic Republic of Iran, Finzer v. Berry, and Teleorn v. Libyan Arab Republic. My observation is that in these cases, Judge Bork adhered to 9 very traditional principles concerning international law, which I'll enumerate and describe. These principles were so clear, so established, that they did not seem very remarkable at the time. During his confirmation hearings, very little was made of these cases, especially in comparison to his other cases. Judge Bork isn't really known for his international law jurisprudence. But Judge Bork's international law decisions over the years have become notable because other judges, particularly those on the Supreme Court, have chosen not to follow each of these very basic 9 principles that I'll go through. As I'll show, in important litigation arising especially in the war on terror, the Supreme Court has rejected or ignored almost everything that Judge Bork said. I suppose that means that Judge Bork did not leave much of a legacy in international law. But again, I don't think he was really trying to do that. Instead, he didn't invent these principles. He just followed them. And why look at them now? Well, I guess one reason to look at them now is just to think back at what was lost 20 years ago in the confirmation battle. Let's start with the Demjanjuk v. Mies case. In that 1984 case, an accused Nazi war criminal filed a habeas petition seeking to block his extradition to Israel. He claimed that the extradition violated a recently ratified genocide convention. But Judge Bork rejected that claim on 3 grounds. One was that the treaty was not self-executing and there was no implementing legislation. Therefore, a private individual could not assert rights under the treaty. In addition, he said that the treaty had not yet gone into effect. Even though it had been ratified by its terms, it was not to go into effect until 90 days after ratification, and that period of time had not elapsed. And finally, the treaty addressed extradition only for the crime of genocide, and Demjanjuk was not being extradited for the crime of genocide, but instead for the crimes of murder and malicious wounding. Now, if we step back and sort of think about what principles were applied in this case, I think we can see 3 of them. One is that treaties do not bind the United States as a matter of international law or national law if they're not in effect in the United States. The second one is that even if treaties are in effect, courts cannot enforce them unless they're self-executing or unless there's some kind of implementing legislation. And the third is that the text of a treaty, just like the text of any legal document, controls its meaning. It didn't say murder, it said genocide. Now, these principles seem very basic, something maybe for the first day of international law class, but keep them in mind because we'll come back later to them when we talk about what the Supreme Court has done. A second case was Persinger v. Islamic Republic of Iran. Marine Sergeant Gregory Persinger was one of the U.S. Embassy guards who was taken hostage at the U.S. Embassy in Tehran. After his release, he and others sued the Islamic Republic of Iran seeking damages for their seizure and detention. Judge Bork, though, writing for the court, did not allow the case to proceed. He concluded that the court lacked subject matter jurisdiction based on the sovereign immunity of Iran. Now, he didn't make up this principle. He simply followed a federal statute. The federal statute says a foreign state shall be immune from the jurisdiction of the courts of the United States. Now, there was an exception to the statute. The statute contained an exception for injuries caused in the United States. But Judge Bork concluded that the U.S. Embassy in Tehran was not in the United States, even though the United States, of course, exercised control over it. Again, from this case, I think we can see a fourth and fifth principle. A fourth principle would be that Congress by statute can strip the federal courts of jurisdiction over cases involving international law and foreign affairs. And the fifth one would be that U.S. installations outside of the United States are not within the territory of the United States, even if the United States exercises control over them. These propositions were also well established at the time of the case, and they didn't surprise anyone, although, as we'll see, they haven't strictly been adhered to. A third case was Finzer v. Berry. Father Finzer and other anti-communist activists wanted to protest in front of the Nicaraguan and Soviet embassies here in Washington, D.C., but there was a D.C. statute which prohibited displaying placards within 500 feet of a foreign embassy if the placards would, quote, bring into public odium the government of any foreign country. The plaintiffs claimed that the statute violated the First Amendment because the prohibition on the placards was content-based, viewpoint discriminatory, vague, and overbroad. Judge Bork rejected these arguments and upheld the statute. And later, the Supreme Court reversed some of what Judge Bork said about the First Amendment. But Judge Bork's opinion for the D.C. Circuit is still important because it applied two fundamental principles for deciding international law cases. The plaintiff's challenge to the statute required the court to determine whether the government had a compelling interest in passing the statute. In evaluating this argument, Judge Bork observed that Congress had the power under Article I, Section 8 to define and punish crimes against the laws of nations, and then looking at the Federalist Papers and other historic documents, he determined that the framers understood that the protection of foreign embassies from insult was one of the central obligations of the law of nations. In addition, Judge Bork said that, well, in cases involving foreign affairs, there should be deference to Congress and the President, to the political branches, when they choose the means of carrying out these foreign affairs. Based on these factors, Judge Bork agreed that the government had a compelling interest. Now, I think just looking at what Judge Bork said in trying to evaluate the compelling interest, we can see a sixth and a seventh principle. The sixth principle being that history helps establish or reveal the power of the government over foreign affairs, and the seventh would be that courts should defer to the President and Congress on legal issues concerning foreign policy. Again, nothing tremendously remarkable, although you might disagree about the application of those doctrines, nothing really remarkable about the principles themselves. Now, the last case is Tel Oran v. Libyan Arab Republic. This case grew out of, or rose out of a horrific terrorist attack that occurred in Israel. Some of the victims and some of the representatives, it killed dozens and injured many more. Some buses were hijacked and people were murdered. The victims and some of the representatives brought suit in the United States. They sued the Palestinian Liberation Organization and other defendants whom they claimed had orchestrated the attacks. Judge Bork and his two colleagues who heard the case all agreed that it should be dismissed, but they disagreed on the reason that it should be dismissed. And so if you look at the case, it's a little peculiar. There's a very brief one or two paragraph per curiam opinion saying the case must be dismissed, and then there are three concurring opinions, each stating a different reason for why the case should be dismissed. Judge Bork said that the case should be dismissed because the plaintiffs had failed to state a cause of action. The plaintiffs had claimed in part that they had rights that they could enforce under the Geneva Conventions and under the Hague Convention governing the law and customs of war. Judge Bork rejected that argument, saying that, well, those statutes are not self-implementing. The plaintiffs hadn't cited any statute which gave them a cause of action under those statutes. And furthermore, he said, a treaty should not be interpreted in a way that could never possibly have been intended. Judge Bork observed that these laws mostly governed the rights of prisoners of war, and he said, and this is in 1984, he said, to think that someone captured in a war could bring a private lawsuit was remarkable. There could be thousands, even hundreds of thousands of lawsuits filed by prisoners of war who might think their rights were violated. Those lawsuits might be beyond the capacity of the courts to resolve, and that innumerable private suits at the end of the war might be an obstacle to war. They also argued that they had rights under the first protocol to the Geneva Convention, a separate convention that was dated from 1977, but Judge Bork said that they could not assert rights under that protocol because the United States had not ratified it. And then finally, they claimed rights under the Alien Tort Statute, but Judge Bork said that that statute merely created jurisdiction. They needed to find a separate cause of action. They hadn't identified any separate cause of action, and that separation of powers concerns should prevent the courts from creating implied causes of action which might interfere with the conduct of foreign relations. You know, I think in that decision we can see the first two principles that I mentioned before, the idea that treaties which aren't self-executing can't be enforced by private individuals, and also that treaties that aren't ratified are not binding in the United States. But we can also see two additional principles, which is that treaties should not be construed to produce intolerable results, like allowing all kinds of prisoners captured in a war to bring private lawsuits, and that separation of powers concerns should limit judicial innovation in matters that concern foreign affairs, like the creating of implied causes of action. Now, these 9 principles, as I mentioned before, I think were rather unremarkable at the time that the decisions that Judge Bork made were rendered. They didn't play a large role in his Supreme Court confirmation battle. But I think as events have unfolded, they have become more noteworthy. And I say this because the United States now finds itself in the middle of a great international crisis, the global war on terror, which has produced more litigation perhaps than any war in history. The Supreme Court has recently had to decide several very important cases concerning the rights of detainees. And in those cases, it seems to have systematically gone through and rejected each of these basic principles that Judge Bork simply cited and applied in his cases on the D.C. Circuit. The cases I'm referring to are Hamdi v. Rumsfeld, in which the court held that due process required an independent tribunal to determine whether detainees are combatants, Rasul v. Bush, in which the Supreme Court held that the federal courts had habeas corpus jurisdiction over detainees held at Guantanamo, and Hamdan v. Rumsfeld, in which the court, among other things, struck down the use of military commissions, at least as they were then constituted, for trying enemy combatants for war crimes. Let's just go through some of these principles. The first principle was that treaties do not bind the United States if they're not in effect in the United States. Well, the plurality in Hamdan didn't see it that way. The plurality in Hamdan said that the tribunals, in part, violated fundamental guarantees of judicial fairness found in Article 75 of the first protocol to the Geneva Convention of 1977, even though the court recognized that the United States has never ratified that protocol. The second principle was that even if treaties are in effect, courts can enforce them only if they're self-executing or if Congress has implemented the treaty's terms through legislation. But the court found that the military commissions violated the Geneva Conventions. Well, how was that possible? Well, the court didn't actually say there was a private cause of action, but it did say, well, when you talk about the president's inherent war powers, those inherent war powers have to be limited by the laws of war, and the laws of war include the Geneva Conventions, and therefore the president is constrained by the Geneva Conventions, and a detainee charged with conspiring with bin Laden and others to commit murder and other terrorist crimes could enforce that guarantee. As Justice Thomas said in dissent, well, the court's argument overlooks the idea that the judicial non-enforceability of the Geneva Conventions is also part of the law of war. And the result was, though, that the Geneva Conventions were enforced privately. The third principle was that the text of a treaty, like the text of any legal document, controls its meaning. I think you'd be pressed to argue that that's what the Supreme Court was doing when it interpreted Article 3 of the Geneva Conventions. Article 3 is a provision which applies to conflicts not of an international character. And the Supreme Court said, well, the global war on terror, this is the war that's being fought in Yemen, in Afghanistan, in Iraq, in Somalia, in Pakistan, the Philippines, in the United States, was such a war not of an international character. Fourth principle was that Congress, by statute, can strip federal courts of jurisdiction in cases involving foreign affairs. Well, the Supreme Court never said it's not possible, but it certainly seems to be impossible. The Supreme Court in Rasul v. Bush overruled precedent to find that the habeas statute did not require the detainees to be within the jurisdiction of a court. And then when Congress responded by passing the Detainee Treatment Act of 2005, a law which was aimed to end all the litigation arising out of Guantanamo, the Supreme Court said that it didn't apply to pending cases, which meant that it didn't apply to any cases because over 600 habeas petitions had been filed on behalf of everybody at Guantanamo. The fifth principle was that U.S. installations outside of the United States are not within the territory of the United States, even if the United States exercises control over them. We're going to see more about this because in the Rasul case, even though it was a statutory decision with respect to the habeas corpus statute, both Justice Stevens and Justice Kennedy said in their opinions that Guantanamo was, well, though they didn't have to reach this for their holding, was because of the nature of the control perhaps better considered jurisdiction of the United States. The sixth principle is that history helps to establish the power of the government over foreign affairs and international law. Well, the court used to follow this principle. It certainly did in the World War II era cases concerning military commissions. If you look at the Quirin case, the Yamashita case, the Eisentrager case, they're full of discussions of history. But the court doesn't do that very much more. You didn't see much of that in the Hamden case, especially not when Hamden overruled or contradicted the Quirin, the Yamashita, and the Eisentrager cases. I think the seventh principle is that courts should defer to the President and Congress in matters of foreign policy. The Supreme Court did not defer in Hamden when it substituted its interpretation of the Geneva Conventions for the President's, and it didn't defer in Hamdi when it refused to defer to the President's determination of who is an enemy combatant and who is not. The eighth principle is that treaties should not be construed to produce intolerable results. The one that Judge Bork suggested would be, well, lawsuits by thousands of prisoners who have been captured in a war. I don't think I have to say too much about that. The ninth and final principle was that separation of powers concerns should limit judicial innovation in matters that concern foreign affairs. And again, if you think of all the precedent that the Supreme Court has overruled in the Hamden case and in the Rasul case, it would be hard to say that there wasn't a lot of judicial innovation going on. So what should we make of all this? Well, as I said before, I don't think we can say that Judge Bork has created a great legacy in international law, at least not a legacy in terms of what the courts have been following. Courts have not followed the simple principles that Judge Bork followed in his D.C. Circuit cases. Judge Bork didn't create those principles. He just followed them. He didn't intend to create a legacy, I suppose, but one was not created in any event. But I do think it's worthwhile to look at these cases. 20 years have gone by since the confirmation battle, and I think this is just one more area where you see what was lost because of the results of that confirmation battle. Many people think it was about constitutional law, but it's not just constitutional law. It's international law, and I suppose if you look deeply, you'd find it was other areas of the law also. Thank you.
Professor Yu.
I'd like to thank the Federal Society for allowing me to participate in this conference to honor Judge Bork. Unlike many of the members in the conference, I don't have any particular personal connection with Judge Bork, but I feel that throughout much of my career I've been sort of following him around. So when I was a student at Yale Law School, I was a very young person. I recall being in torts class where the professor, who shall go unnamed, was trying to convince us of the virtues of the cheapest cost avoider and why we should have socialized insurance for all torts provided by the government. For some unknown reason, in the middle of class, my torts professor just decided to get into an argument with Judge Bork about the way to interpret the Constitution. And so this was a person I thought I wanted to get to know and admire, and at least admire, because he clearly won the argument without even showing up. Also, as a student at Yale Law School, my international law professor similarly stopped a lecture on some subject, I think it had to do with letters of credit and international transactions, and just paused in the middle of his class and started arguing with Judge Bork about the article in the National Interest that Jeremy Rabkin mentioned. And again, lost the debate single-handedly. The amazing thing is that the article, I'll talk a little bit about later, the article is written in 1989. And I think is quite prescient and timeless. It's also worth looking at some of the other articles in the same issue which have clearly stood the test of time, like Francis Fukuyama's reply to my critics about his theory that the end of history had occurred. I'll note that it took him as many pages to write that article as Judge Bork did in his. And then the classic, will the Soviet Union survive until the year 2000? So it gives you a sense of how, I think, how forward-looking he was in writing his article. And then, other places I've been, when I showed up to clerk at the D.C. Circuit, I noticed that liberal judges like Judges Mikva and Wald were still infuriated by Judge Bork's opinion as in Telhorn and trying to figure out how to get around them unsuccessfully. I finally did catch up with him. I finally crossed paths with him at the American Enterprise Institute for a summer. And I thought, after seeing so much of him secondhand or from a distance, that he'd be taking it easy. But in fact, as soon as I walked into his office, he was, I suppose, quite feisty that day and got into a long 2-hour argument with me about the government's litigating position in the terrorism cases. And even though I think he believed the government was right on the law, that the federal courts would not exercise jurisdiction over the terrorism cases that Greg Maggs discussed, he also predicted quite pessimistically that he was certain the Supreme Court would do it anyway, and he turned out to be right again. So it's just a pleasure for me to be able to participate in talking about his views on international law, having been influenced at a distance by him. What I'm here to talk about is the book Coercing Virtue, which was his most recent book, and I could sort of summarize his thesis about international law quite quickly. One, he thinks that what he calls the American disease of judicial review is rapidly spreading, not just in the United States, but to other countries in the international law system. He thinks that judicial review is particularly an American disease because it gives the power to judges to make decisions that deprive democracies of the right to make their own choices about a great variety of things, most notably social values. Most interestingly, he associates judicial review with the agenda of an elite that is trying to fight a cultural war to move society to the left, and uses judicial review as a tool to win the wars that it cannot win in the democratic process. And he, at least in this book, repeatedly refers to this elite as the quote-unquote new class, which he lists as including journalists, academics of all disciplines, people who work in museums, foundations, and radical environmental groups, activists, and then he waited, I think, for the worst category, the quote-unquote denizens of Hollywood, unquote. Is there anybody worse that he hasn't included in that list? I don't think so. But his main idea was that there's a group that is now international, that shares certain elite values, that are members of these professions, and they use the function of judicial review as a way to impose those values without going through any democratic process. Now, as regards to international law, he wrote, as Jeremy Rabkin mentioned, before the Supreme Court had decided the terrorism cases, before it decided Roper, which struck down the use of the death penalty on those who were under 18, before it decided Lawrence versus Texas, which which struck down laws against homosexual sodomy, before it decided Virginia versus Atkins, which prohibited the death penalty of the mentally retarded. All cases in which the majority of the Supreme Court looked to foreign law and international law as support for its outcomes, Judge Bork, before all those decisions, predicted that the Supreme Court was to start using foreign law as a way to get around the original understanding of the Constitution, the constitutional text, and the democratic process. The only thing I would add as a comment on his argument here is that it's not really clear to me that this is the functioning of elites. If any of you have the misfortune to travel to Europe, you will find, I think, that many of the values that Judge Bork associated with the new class is not just an elite, are not just elite-held views, but are views, I think, that are quite common in European society at this point. I think that European democracies consistently now are voting to shape policy or move policy in the direction of what Judge Bork calls the new class. So the question is this really, at least in the European experience, a function of the problem that he saw in the United States? Or are we really seeing, I think, maybe a difference between the United States and Europe? Another commentary I would just like to register in terms of this part of Judge Bork's argument is also that he never really, I think because he thought the process was so illegitimate, he never really got into questions of how would you actually do it, right? If you really took foreign law seriously, how would you do it? Would you look at all the countries of the world? So for example, in all these cases, the Supreme Court has pretty much only looked at European cases and hasn't looked at, for example, the practices in Africa, Asia, the undeveloped world, the Middle East, and I think for quite obvious reasons, is because the outcomes of such a survey would be against the court's preferred course. Also, the court has not been consistent in looking at foreign law. For example, it has looked at foreign law in the death penalty area, but as Justice Scalia mentioned in his dissent in some of these cases, the court doesn't look to see what the laws on abortion are in the rest of the world. It doesn't look to see what the rules on the exclusionary rule are in the rest of the world. The other main argument that Judge Bork made in his book and touched on in the National Interest article was his claim that this new class acting through instruments of judicial review, either at the international level or in the Supreme Courts of many nations, would try to use international law to restrain the United States' ability to use force abroad. And this, I think, is quite, again, quite prescient. This was written before the Iraq War. And here, I think this is an amazing prescient quote. He wrote, "International law actually makes moral action appear immoral. It can hardly be doubted that, in the view of America and many Western democracies, it would be a moral act to help a people overthrow a dictatorship that had replaced a democratic government by force and to restore democracy and freedom to such people. Yet when our leaders act for such moral reasons, they are forced into contrived legal explanations. The implausibility of those explanations reverses the moral stance of the parties." And so here I think one interesting thing is Judge Bork was critical of international law. As Jeremy Rackin said, he sometimes argued that international law wasn't even law at all because it wasn't enforceable and no one seemed to obey it. But I think the other point he makes is that, and I think this also is somewhat consistent with his arguments about domestic law, is that international law is particularly in some way detached from any notions of morality, and that for something to be effectively law, it has to be in somewhat of, it has not to be lockstep, but somewhat related to the moral principles that should operate. And in the international system, he was critical of the use of force rules, which I think he quite accurately read as prohibiting the United States from intervening in smaller countries or countries struck by human rights abuses. It can only use force in its own self-defense. But again, the point I'd like to make here is similar to the one about international law. Is I'm not sure whether this is the view of elites using judicial review to impose their values, or whether, again, this is a difference between the United States and Europe. I think if you saw in the lead up to the Iraq War, I think large percentages of the populations in the European countries were opposed to the Iraq War, and many of them believed that it was illegal under international law and that this was actually a reason to oppose the war because it had never received UN Security Council approval and was not arguably in the United States self-defense, according to this argument. It also seems to me, as David Ridkin mentioned, that international law in this area is quite advantageous to the national interests of Europeans, not just the elites. If you have this view of international law, which depends on collective security, which doesn't allow the legitimate use of force by individual countries unless approved by a supranational government, hopefully you enter this world where you don't have to spend much on your own self-defense. Hopefully you live in a world where countries are not going to invade each other. And if worse comes to worse, you can always rely on the United States to come and use force to save you. Again, I don't think this is necessarily elite. I think it makes complete sense in terms of the European situation, which has quite heavy expenditures on social programs, does not want to spend money on defense, and quite frankly has a bad history when it comes to the use of force against each other. I think the mistake there is that they associate the success of peace in Europe and the stabilization, the German issue, the expansion of Europe and its security, to the use of international law, use of treaties, rather than to the balance of power that occurred between the United States and the Soviet Union during the Cold War, and the continuing superiority and strength of the United States in maintaining peace in Europe. So the last thing I'll say is, in the end, there might be a positive story for international law that I think Judge Bork overlooked. The one thing that I found about his last book was that it's somewhat pessimistic. I think he's very good at identifying some of the trends that are occurring. There's no real prescription for change. There's nothing in the book to tell you how to reverse things. And it can, for that reason, can be quite depressing. On the other hand, I think he could have been more open to the idea that international law could be a way for the United States to put into place the kind of world it would want. Right? One thing that David Rivkin says that international law changes along with custom, and one thing we may not take advantage of is the fact that the United States can change international law in a positive direction that would make the world a place that would be more easier to run on more liberal values, where we allow intervention for purposes of putting into place democratic governments, or we allow the use of force abroad to reverse aggression, even if it's not approved by the UN Security Council, and even if it's not in our self-defense. So that I'd like to close and just say that just make one last comment about why Judge Bork got interested in international law, which I never heard from him, but it always seemed to me that he thought that international law was potentially the worst area where you'd see the concerns they had about the domestic system run the most rampant, where you'd see the worst dysfunctions in the way law was made and enforced. For that reason, though, it also, I think, may be the area where you might be able to change things in a positive direction more easily, that it may be easier to change the international legal system towards a system that would be more consistent with morality than you might be able to in the domestic constitutional system. Thank you.
Well, we actually have unusual such panels. Thank you all for an excellent presentation. We've got about half an hour, which we can hopefully engage in questions. Please identify yourself and you'll be recognized. Use the mic. Gene?
I was interested in the other panel's reaction to Professor Yu's last suggestion. What could be done? What should the attitude be toward international law? What could be done? What would your suggestions be in that area? Okay, keeping in mind, Professor Yu was saying, "Gee, this is really something which, done right, we could actually make some pretty good use of from an American perspective. These rules, these laws could be used to promote some of what we'd like to do."
Well,
and I'm just interested in what.
At the risk of being self-indulgent, let me just say briefly, I totally agree with John. I think that there's no choice but to engage in this particular battlefield, and it's not really even creating new law. Traditional international law would do quite nicely. So in many respects, it's a battle for restoring international law to its proper parameters, just like so many of our constitutional debates are about going back to the true Constitution. The reason we have no choice is because the argument that international law is fundamentally illegitimate, however appealing and satisfying maybe intellectually, is just a losing argument given the modern sensibilities. And basically, we either fight to define international law in a way that's compatible and collegial to us as a sovereign country, or we're going to let somebody else define it for us, and we'll be protesting that it doesn't matter. Unfortunately, it does matter. But maybe others would differ.
I agree with that, too. And I also think if you set this up the way, John, you did, which, I mean, was entirely reasonable, I'm not saying it as a criticism of him, but if you think of this battle the way a lot of us have gotten used to, which is we say this and the Germans say that, or the French say that, and then we have these battles in the UN, you're just missing the fact that a lot of countries are very sympathetic to things that we care about. I I mean, India and China have been very insistent that Kyoto doesn't apply to us. Or actually, it literally doesn't apply to them. But I mean, they're very insistent that there can't be some customary law development which allows us to be bound by preferences of people in Europe if we don't consent to it. They're very sensitive to that because they see that it will work against them. Good for them. I've been told that a lot of Chinese success in cultivating, let's call it friendship in Africa. They sprinkle money, but also they say to the Africans, you're right, your sovereignty is threatened by international prosecutions, by international human rights agitation. I don't see why we can't compete with the Chinese in saying, yes, we also think that independent countries should be allowed to, for the most part, decide matters for themselves. There are certain exceptions which we ought to be firm about. You know, it's fine, I think, for us to say genocide is not the exercise of sovereignty. But we would do much better in the world if we said that is an exception and not a for example. And I think we, instead of being apologetic about times when we make exceptions, we should just say it's not exceptional. We are insisting on what we think are our rights as a sovereign country, and we expect others to do the same. And I think we'll get a much better response, at least from many countries, if we are less hesitant about that.
I think Judge Bork is correct to be pessimistic for the reason that he stated and that John and Jeremy have both pointed out, that in many ways, when you're engaged in a dispute about international law, even if you win, you lose, because instead of justifying your actions based on the substance, you have to justify your actions on some legalistic defense, which never carries a lot of weight, especially given that there are so few clear precedents. But if the United States is going to play the game of making international law arguments, I think the United States ought to do more to exploit its advantages, such as its veto on the Security Council. Whenever a nation wants to use force in self-defense, Article 51 of the UN Charter says that that's possible, but you have to write a letter to the President of the Security Council explaining why you're doing it. The United States sometimes has done this to great advantage. So, for example, after the 1998 African embassy bombings, the United States wrote a letter to the Security Council explaining why this was an armed attack on the United States and why we were going to respond by firing missiles at Somalia and Afghanistan. The great thing about having a veto on the Security Council is that nobody can say anything contrary to that letter. Well, that letter has been immensely useful in determining what has been an armed attack. We have a number of advantages like that, but we don't always make advantage of, take the full advantage of them. So, as I said, I do agree that one reason to be pessimistic is that when you argue about international law, you lose even if you win. But if we're going to try to win, at least we should take advantage of things that we can do that nobody can say otherwise, such as exploit the fact that we have a veto on the Security Council.
Thank you.
Hi, my name is Andrew Jones. I'm going to be returning as the Vice President of the Loyola Los Angeles Federalist Society chapter. Actually had a question for Professor Yu. Again, please correct me if any of my recollections are wrong, but I was reading media reports perhaps a while back that you really suffered some pretty outrageous treatment, both, I don't know, from faculty and from students, but I know at least from students at your own campus in regards to your advice you've given the current administration about treatment in the war on terror of detainees. And I was curious to find out if you had any thoughts, and the rest of the panelists had any thoughts about, is there something about the Iraq war, or is it just international affairs in general that kind of inspires these kind of wild passions that would lead people to do stuff that would be otherwise, I would think, outrageous in a law school environment to their own professor, no less?
You've not been to Berkeley, have you?
I went to UCLA, but apparently it's a different world up there.
I think there is something about I do think there's something about the Iraq War that is driving people crazy. Jeremy has actually written about this, so I defer to his views, but and I don't think it has to do with international law. I think it just has to do with the success of the war, whether it's seen as going badly or well. I mean, I think, in the first year of the war, we didn't see the kind of you didn't see the great drop in President Bush's popularity. You didn't see, I think, a lot of the protests that in the rest of the country that you see in Berkeley. They're still going against the Vietnam War. So I think that has a lot to do with it. I also think, at least in regards to the war on terrorism, I think Judge Bork is right. This is a question where you have elites at war with sort of what would be popular opinion. At least in the things I've seen, most Americans still think many of the things the government has done in the war on terrorism are generally good policies and ought not to be changed. And you don't see the presidential candidates campaigning on reversing a lot of the war on terrorism policy. So I think one thing you've seen is that the hostility to the Iraq War has bled over into hostility about the policies in the war on terrorism. I think, in some respect, unjustifiably so. Although the administration, in part, may be responsible because of its rhetoric, attaching the two, aligning the two together. In terms of the protests at Berkeley. There's protests at Berkeley about everything all the time. And so to the extent I get protested, I'm in there with McDonald's and Citibank. I wish I had as much money as they did for undergoing the same troubles. But it's not uncommon to have protests at Berkeley. I went and spoke at your law school last year, and I don't remember there being any protests. There were a lot of weirdos, but that's because you're in Los Angeles, but no protests. I would defer to Jeremy totally on the view of the Iraq War and war on terrorism. I'm curious.
Hello, David Wagner, Regent University, and I'm asking this only because Judge Easterbrook isn't. In this forum last November, he gave a very interesting talk making the claim that international legal authorities aren't really driving in the sense of determining any of these Supreme Court decisions that we've been talking about. They are icing on an already baked cake. And I'd like to ask the panel for their views on that.
Of course.
I think their ornamentation.
How could it possibly be that judges who don't care about the United States Constitution, don't care about American law, don't care about law in any other context, would suddenly be transfixed by international law and say, oops, we got to give up all of our biases and all of our commitments and all of our programs and just do what the law says? That can't be right.
But if he's right, then strictly speaking, we don't see the court relying in the strong sense of the word.
Yeah, technically that is also right. I mean, and indeed, my expertise is I don't work as hard as other people, so I get to watch C-SPAN, and I've now seen all these different C-SPAN presentations, or anyway, C-SPAN is relaying to you someone else's presentation in which different justices of the Supreme Court say, oh, well, blah, 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 blah. That's summarizing Justice Breyer's position, for example. And they always say, they always make a point of saying, the people who defend the appeals to foreign law, we're just talking about it. I mean, they say that straight out. Well, it's not binding on us. It's just suggested. I don't follow that, but clearly it means they don't feel that this is something which is would get in their way, right? And I think that I'll say one other thing about this. I mean, I did not hear Judge Easterbrook's talk in November, but I wouldn't conclude from what I don't want to leave you with the inference that this isn't important because they're not letting it get in their way. I think it is somewhat important because what it is doing is building up an alternate structure of authority. And the fact that it's a very manipulable structure doesn't make it less disturbing. In some way, it makes it more disturbing because it's just saying, I've accumulated a whole stack of get-out-of-jail-free cards, which I can use whenever I want to. That doesn't make me feel like, well, these people are really going to be law-abiding. It's very manipulable, and I do think it is sort of worse than what it does to them is what it does to onlookers. And it's true. I mean, most people don't pay that much attention, and the people who do pay much attention are often very corrupt themselves because they're law professors. But it does get reported in a general way, and people do hear that, it's transnational, international, blah, blah, blah. And I think at least half of America finds this, not just disorienting, but disturbing.
Let me just add one thing. It's certainly I agree with Jeremy, but it's possible that this practice sets that, in addition to its inherent dangers that Jeremy mentioned, sets a very dangerous dynamics, because there are instances where you have some rules of international law, not the ones we've accepted, but nevertheless that harden, would continue to harden as other states use law as a tool to discipline American power. And there are many instances where the judges have spoken with admiration about at least suggestive or persuasive nature of international law, if not binding. We can be in a situation 10, 15 years from now where, in a way, they get hoisted on their own petard, where it becomes difficult to completely disregard these rules. So it's one of those exercises that's dangerous in its near-term implications and very dangerous in its long-term implications, because when judges do that, not to sound too dramatic, they really erode the legitimacy of our institutions. I mean, I can say it ain't theirs to erode, but they do. Any more when you have other branches of government that are acting extra-constitutionally and they get away with it, bad practice creates for bad law.
David, can I make a point? I used to think it was also ornamental, essentially, that it was, like the way that medieval scribes used to put little drawings on the inside of the big letters on the first page. Everything is just for fun. But actually, Judge Bork has this really interesting, in his Coercing Virtue, a very interesting description of an event that occurred in 2000 in London, where 4 Supreme Court justices went over to meet with prominent European judges and lawyers. And he says that the lawyers and judges from the other countries just heaped abuse on the Supreme Court justices, particularly Justice Kennedy, with London lawyers in particular saying things like, "You're turning your back on the continent, and your system seems quite certain has nothing much to learn from us," which I always thought was the whole point of the American Revolution. Then, hold on, sorry. And then he said the mayor, excuse me, sir, hold on.
If you let Professor you finish.
But then he said that Kennedy, I mean, this is surprising, and then he said Kennedy, to his credit, did not, as Judge Bork said, it is great language, he said, did not succumb to this combination of insolent and foreign browbeating and pusillanimous American response. Because a number of Americans said, you're right, we should be citing more foreign legal opinions. But then, and this is why I'm not sure it's so ornamental anymore, is that Justice Kennedy, after this event, is the one who's doing the most citation of foreign opinions foreign law in majority opinions. So it makes you wonder whether it's not just ornamental anymore. The second point, the small point I just want to make, is that's not, Judge Bork, I think, aims his fire on the judiciary. And one, I think, lesson that we're starting to see is that this is not just a problem with the judiciary. So there's a Supreme Court case coming up this fall where the executive branch has tried to order states to reconsider death penalty verdicts for foreign nationals who didn't get their foreign warnings under the Vienna Convention. It's kind of complicated, but essentially what's happened is the president is trying to force states to obey the decisions of an international court, even when the Supreme Court and the lower federal courts have thought that that's not required. So it's not just a judicial disease, this sort of mentality. It may be actually much broader. And one question that's worth asking is, how has this happened in so successful a way, and so, to the point where institutions of government whose interests of the United States or self-interest as an institution are not served by doing this, in fact, willingly go along.
Sure. Would you like to ask?
I didn't have a lot to say. I just had that one question. I'm surprised that Scalia didn't get mentioned, because I've read a lot of his decisions, and he's been very vehement on this subject. He's very anti-imposing foreign law on our system.
Does anybody want to tackle that?
Well, I think I did mention Justice Scalia in his dissents on Roper. I mean, Justice Scalia's in these dissents, I think, it's interesting. There's a difference between the way Judge Bork and Justice Scalia approach issues. I think Justice Scalia basically mocked the majority for being hypocritical. Right? So he basically said, if you really believed in international law, why didn't you look at third world countries for their views on the death penalty and so on? And I think Judge Bork is, at least in his book, is not concerned about this sort of what I would think is more technical issues. He's more interested in attaching it to political movement. And so it's not that he actually doesn't think it's hypocritical. He actually thinks that this is yet another effort by the judiciary to start imposing its own values on American society without the democratic process.
The opinions of the world community are not, thank goodness, those of the American people, said Justice Scalia in Atkins. He's a great American.
Here, here. Please.
There was another era about 50 years ago in the 1950s in which the concern had grown that the Supreme Court in some of its decisions might be approaching the point at which it would declare that some of our international commitments would trump the Constitution. And there was, of course, a congressional and public opinion response, and the congressional response took the form of the Bricker Amendment. And even though that didn't ultimately go anywhere, it appears in retrospect that the court sort of got the message at that time. Do any of you think that any similar response on the part of Congress at the current moment might serve to put the court's resort to international law or comparative law back in its place, so to speak?
Well, first, I would say I wouldn't think of the Bricker Amendment as being unsuccessful, because it actually, I believe, failed by only one vote. The Bricker Amendment was a constitutional amendment to make clear that treaties could not exercise any authority that was beyond the Constitution without the treaty being present. And I think it only failed in the Senate by one vote, and that was after the Secretary of State at the time, John Foster Dulles, promised that no treaties would be signed by the administration and sent to the Senate that would ever raise that problem. So in a way, it was a way the Senate actually successfully, I think, threatened the executive branch not to raise this kind of issue. On the other hand, as someone who worked in the Senate and have the greatest respect for it, I find it inconceivable that would happen today, that you could get almost 2/3 of a vote in the Senate to send a constitutional amendment to the states, overturning some kind of rule of international law or clarifying the relation of the international legal system to the domestic legal system. I do think that the mentality of international law that Judge Bork was very critical of in coercing virtue is really, I think he was quite prescient in predicting that it was going to seep into sort of intellectual discourse. And I don't think you see people in Congress complaining about having to follow international law. It's used as a tool, I think, as some others have said, in interbranch disputes to try to limit the power of the executive or limit the actions of the United States abroad.
Let me just say a couple of things. I agree with John, but the danger is a little more subtle. The Europeans frequently say these days that in their system, the EU treaties and documents trump domestic constitutions. That would not be ever articulated this way in our system. I certainly don't see that. The danger really is that for those people who are inclined to see a lot of ambiguity and vagueness in the Constitution, they would use foreign law, international law, to enrich the content of such words as due process or equal protection or cruel and unusual punishment and whatnot. There's another problem which we really don't have time to discuss, but apropos of the Bricker Amendment, it is certainly the case that there are many things. Well, there are some things that are safe. There are certainly unique aspects of structural separation of powers issues that are so unique to our system that you are not going to be able to grab some foreign law concept to distort it. What really suffers, though, is federalism, because I think we all agree there are huge areas of law that you really cannot cobble a Commerce Clause argument, certainly in the aftermath of Lopez and other cases that adopt some constraints here. Things like regulation of insurance, for example, or regulation of family inheritance issues. So absent a treaty, there's just be no plausible way for the federal government to regulate it. Problem is, if you have a treaty, you pretty much can regulate it that way, and I sort of despair at the root collision between the goals of federalism and sort of a horizontal separation separation of powers and in international law. But I don't know an obvious answer here, since we're not going to have a Bricker Amendment. So the state rights, if you want to call it that, really are the ones that suffer the most. Please.
My name is Andrew Olson. There was discussion earlier today about how over the past 30, 40 years, particularly with the influence of Judge Bork, originalism has become, with the rise of it as a judicial philosophy, has kind of altered the landscape of the way that courts approach opinions, and that now originalism itself has diversified. So we have people like Akhil Amar and Randy Barnett who have originalist philosophies that look in their results very different from Bork's original philosophy. And I'm wondering, because if you read Kennedy's opinion in Roper versus Simmons, it looks like he's just flailing around to find any and every argument he can possibly make to justify the decision he wants to get to. He says that executing juveniles is cruel and unusual because even in the few states that still do it, they rarely apply it. And then on the other hand, he says that we can't allow it to happen because juries don't know how to apply the sentencing correctly, even though it's obvious that in the states where it's allowed, juries are very strict about giving it. And then he also mentions international law, and it just seems like there's nothing guiding him except he has a result that he wants, and he's going to find everything that could possibly be seen to support that, instead of making one simple argument that's straightforward and gets directly to the point. I'm interested if the panel thinks that perhaps when people like Kennedy cite international law, what we are witnessing is kind of the final flailings of a completely intellectually bankrupt way of approaching law, and if we can hope in the future, not necessarily to have results that we all agree with, but at least to have opponents who make logical arguments that are part of a broader philosophical system. Do the panelists feel like this approach towards international law now is maybe just a temporary thing, and that in the future we'll have some kind of more coherent system to oppose?
Gentlemen.
So you're not planning to apply to him for clerkship, I take it? I would just say, just because Justice Kennedy can't figure out originalism and apply it properly doesn't mean that originalism itself has problems. I mean, originalism is a theory of interpretation, and I tend to agree with many of your criticisms of the way Justice Kennedy makes decisions, but what he does I don't think really has much to say about how originalism is doing, as a theory of interpretation, either around the courts or, just one side note, at least in the academy, I think he's been remarkably successful. I looked at this for something else, and after roughly 1987 and 1988, the amount of originalist scholarship in law reviews has gone up enormously, to the point where I think the citation and quotation of the Federalist Papers seem to have gone up 800%, like about 8 times. You just see 8 times as many law review articles in the same period of citation than you did before the sort of 1986 to 1987 period, and you certainly see arguments not just between originalists, within originalism, but between originalism and critics of the outcomes who will use originalist methods. Even on the Supreme Court, you see this. So the thing I always struck me, even though there are several justices on the court who won't subscribe to originalism, if you look at the 11th Amendment cases, for example, these sort of critics of the court's outcome write these enormously long, quite detailed originalist opinions in dissent. And I don't think that's something you saw much of in the Warren Court or even in the Burger Court. So I think at least that's a sign of success, is that it is not just part of the legitimate discourse on constitutional interpretation, but so serious that it is something that both sides in the debates feel that they need to address. And if you read opinions from the Warren Court on questions where there was good evidence of what the framers might have thought, I think Judge Easterbrook talked about the Appointments Clause, mentioned the Appointments Clause. The early Appointments Clause cases in the Warren Court don't mention the original understanding at all. And there's quite a significant amount of evidence about the Appointments Clause, and if you look at opinions, say, in the 90s, they go through the evidence quite a bit now. And I think that's significant.
Perhaps you could correct me. I thought maybe your question was, is there an analogy between originalism to what we might call, I don't know, internationalism? Was that what you were saying, which is just as originalism? Okay, well, then I have nothing to say.
Jeremy? Well, we got a few more minutes. Don't tell me you ran out of questions. We can ask each other questions, I guess. But, 3 more minutes before the food is served. Oh, sure. Yeah, okay.
Hi, I'm Christian Bond, and I'm with the General Counsel of the Army's office. My question's in my personal capacity. It's after 5. I have a kind of a policy question for you. I'm wondering everybody's opinion on whether the United States should just, as a political matter, and the politicians should more openly embrace using international legal arguments to support the use of force. We seem to be hamstrung because the Europeans use this language, and it has some purchase over there that it doesn't have here, which is one of the reasons we don't. But we will act, and then we have our lawyers talk to their lawyers, but we don't openly say this is to support international law. And I think that being the major actor in the world in the use of force, we could help shape international law stronger in our favor if we said, not only is this right, which I think is what the American people want to hear, but also this is to support international law and, for example, uprooting tyrants or fighting terrorism. So this is a problem we're particularly hamstrung as a country, I think, because American people don't really care about international law, I think. But you know, we're with one hand tied behind our back. So I'm just curious what your thoughts were on that.
Could I? Of course. I hope this is somewhat responsive to your question. There are some real deep asymmetries in the world between the United States and any other country. I mean, we have 12 aircraft carriers, is that the right number? 14, whatever it is, and nobody else has one. We have the capacity to project force all around the world, not always successfully, but anyway, quickly. No other country can do that. That is, you know, on 24-hour notice, send troops or cruise missiles or something to a distant location. I mean, we are in a very exceptional position. And that has all kinds of difficulties associated with it. We shouldn't blink that. But I think it's really wrong for us to fall into this idea, and this I slightly disagree with John Yoo. I mean, I'm sure I agree with all of his conclusions, certainly all the sensible conclusions, but just his way of framing this, I think, is a little bit misleading. I think we shouldn't let ourselves fall into the notion that, well, there's this just absolutely inevitable irresistible tension between our views and the views of the Europeans because they have high welfare spending and they don't have a military, but we have a military, so therefore, I mean, if they are more frightened, they will be more sympathetic to the use of American force. They haven't been frightened enough, but give them time. It won't take much time. And I mean, to think that there's this inherent conflict, or anyway, inherent standoff between our views and their views, which overrides everything else, is really to take their views at face value. I mean, that only works if you actually think they have discovered this magical force which allows them to defeat the operation of gravity, to use my previous metaphor. And since they are not affected by gravity, they don't actually have to think about military security. Not being affected by gravity, they don't actually have to think about, if you have a military, how would it be used? They don't have to think about how their enemies or terrorists or other people might get in their way. Now, this is all ridiculous. Of course they're going to have to think about this. And when they think about it, you know, call me a cockeyed optimist, but I think they'd rather have us win than the alternatives. Any of them, including Germany, whatever they are, right? So, I mean, I think we shouldn't let ourselves get so discouraged and think crazed judges will take over the world and nothing can be done about it. I mean, no, no. And I think, since I'm somewhat optimistic about Europe, and I think we should all think, I mean, the election of Sarkozy is a rather impressive thing, because he said straight out, I'm the pro-American candidate. I mean, he said it more or less in those words. And everyone said, oh, très bien. That's something. And if I'm, going to express optimism about Europe, let me say I'm even more bullish on America. I think it's very hard to believe that people will have patience for Supreme Court decisions constraining the use of force if we have another terror attack, which, sad to say, it's probably will. So I wouldn't be too, fatalistic that there's just nothing we can do. But it would help in the meantime if it would help the next president, whoever he or she might be, if we were a little more, the current administration were a little more clear to the country about what's at stake if you allow difficult precedents to accumulate. Not that they will make it impossible for us finally to do what we have to do, but they'll make it harder, and we'll do it more slowly and more hesitantly when there may be situations where we need to do it quickly and decisively. I don't want to discourage the John Yoo of the next administration.
I would just say I don't want to be portrayed as sort of wrapping myself in the UN flag every time I go to sleep. I mean, that's not my intention. I think what we should do is just be more open that we want to change the rules and change them. And I think there's this difference between Europe and the United States about how we think of the rules on the use of force. But I think one thing that's very odd, you work in this area as well, is this is an area, international law, which is remarkably resistant to facts, proof, evidence, and so on. I mean, if there's anything that really hasn't worked, right, it's been this idea of collective security. I mean, the League of Nations failed utterly. The United Nations really hasn't worked. And yet still the governing legal regime is this criminal law system where all uses of force are banned unless you're defending yourself, which doesn't describe what nations have done and doesn't seem to really fit with the way the world works. So I think basically you have this huge disjunction between the way the world working and the legal rules, that we ought to just change the legal rules and say, we're done with the UN Charter system. It doesn't work. It never had worked.
Gene Meyer is going to make a brief closing.
I wanted to thank the panelists, which I think you've just done, and I want to make two other short announcements. One, the reception has been moved to the stateroom, which is to the left, just down the hall. So it's in stateroom, left, just down the hall. And I did want to say a couple of very quick thank yous. Steve Calabrese, who spoke at this, also helped to basically plan the speaking part of the conference. And Dean Reuter and Julie Walker in our office did the bulk of the work on the conference. And I also wanted to thank the judge's son, Bob Bork, for having been very helpful with all of this. And I especially want to thank all the speakers and all of you for attending. And let's join us at the reception. Thank you.
Well, I just kept going last. That was the thing. I wanted to say something about something.
This is a very deep